All right, so welcome back to the class today. We are going to touch on fair housing. We're going to talk about the context of fair housing and the laws that are critical to create fair housing so that everybody has an equal opportunity to live where they want to live. We're going to talk all about the Civil Rights Acts, way back from the Civil War up until now. You guys are going to need to know which act brought in which protected class. That is very specific. We're going to talk about some of the other unfair practices that are out there. We're going to describe some of the different practices that you can use and how tricky they can be, and some of the wording that you guys can and cannot use. And we're going to talk about how important it is for you guys to understand that they do not play when it comes to this law. This is a law you can actually lose your license over. All right? So it is very important that you understand. Now, I don't believe that there is blatant discrimination going on now, to the tune of when someone says, well, I'm not going to rent to you because you're this. That's not as big a problem now as some of the small stuff that we'll talk about, and you'll see what I'm talking about. I like to start this chapter off. I love a large group like this because it generates great conversations. I love to start this chapter out with being the white male. I'm the top of the food chain. At least that's what everybody seems to think. All right? You're going to see that there is a lot of, especially right now, we're in a big turmoil with all this that went on the last week of fighting and killing and all that. And I do think we've got some issues that we need to iron out, and we can consider this a safe place if you guys want to talk about any of that stuff. But these laws pertain to the housing. What we are going to cover is the federal fair housing laws. These are federal laws. Every state has these laws. Now, with that being said, some states actually have what they call an overlay to protect more people. And how the laws work in the United States is when the feds make a law, the states can make a law too, but they cannot make a law that's least restrictive or less restrictive. They can make a law that's more restrictive. Some states have done that with the fair housing. Let me give you an example. The fair housing law, federal fair housing, protects 7 classes, and you will get to know them and love them. They're race, color, religion, national origin, sex, familial status, and disability. All right? Washington State also adds in military status. They also add in the LGBT status. They also add in, there's another class they protect. So a state can be more protective, but not less protective, okay? In Indiana, I like to say that Indiana is what we call a copy and paste state. So we only use the 7 protected classes here in Indiana. We do not have an overlay of more restrictive like Washington State does, all right? And that's true if anybody's into any kind of governmental agency stuff. Our EPA laws are exactly the same as the Fed. Our OSHA laws are the same as the Fed. We have not been more restrictive. You guys know what the most restrictive EPA state there is? Has the most EPA laws? You guys are going to be shocked when you hear it out. Everybody wants to say California. Kentucky. Kentucky, because of all the coal mining and deaths and stuff like that. They have a lot more restrictive EPA laws than the feds do. All right, so just remember the overview there on page 32. These are the federal laws. All right, some states have more. Indiana does not. This does not necessarily apply to just you. This applies to your client as well. And I'm going to give you a true story of how this actually, and maybe I'm going to have to backtrack on what I said, because this story happened when I used to own a Century 21. It was Century 21 Preferred Properties downtown Indianapolis. We had you guys know what the home show is, right? We went to the home show, and we had a big booth, Century 21 booth. And this guy came up, and for the premise of this story, because I want to show you how he said it, I'm going to use the word apple instead of the N word. All right? So the guy literally came up to our booth and said, hey, do you guys go as far south as Martinsville? And I said, yes, we do. He's like, I'd like to list my house. I said, great, we can do that. And he said, but I don't want you to sell it to any apples. I mean, he didn't look around. He didn't flinch. He didn't whisper, nothing. Just blatantly right there in the middle of the home show, in the middle of the aisle.
He was white, right?
Yeah, he was a white guy. And we're standing in the aisle talking to him, my partner and I. Her name was Betsy Taylor. She was my partner. And Betsy literally takes one step back from him. And I said, you know that's a violation. And he said, well, I'm sure it's a violation, but I'm just looking out for the apple because we don't like apples down there, and I don't want the apple to get hurt. And about that time, we both stepped back behind the table and are like, dude, you need to go talk to Tucker because we're not going to list your property. So you have to understand that it's not just you that can violate these rules. If your client violates the rules, you are by de facto just as guilty, and you have to terminate associating with them, or you can be brought down too. So you have to understand that if something happens and that happens, you have to say, hey, that's a federal law, man. You're violating a federal law. We can't do that. Okay? So here's how this starts. Back in 1866, just after the end of the war, the Supreme Court ruled on this case called the Civil Rights Act of 1866 that it was illegal to discriminate housing based on race. That was the sole category that they chose. All right? Race is the only one. So the Civil Rights Act of 1866 is only based on race. That's our first category of the 7. This is the law that is the big Mama Luca. This is the one that Supreme Courts go back and visit the ruling in 1866 to determine some of the new laws that have been made. So it's the prime law. It's the first one they go back to. It's the first one they look at. When there's questions, they go back and look and do it. However, it was often ignored. Okay? It was being a new law, new country, new problems, new issues. The law was in place, but they tended to disregard it. Then in 1896, there was the Supreme Court called Plessy versus Ferguson. Anybody remember that from their history class? Nobody? One person. Thank you. What's the catchphrase that came out of Plessy versus Ferguson? Separate but equal. It was okay to have separate facilities, separate rail cars, which is what this was about. Was a black gentleman was on a white rail car, and it went on, and they tried to get him to move, and it went all the way up to the Supreme Court, and the Supreme Court came up with this thing in 1896 called the Plessy versus Ferguson Rule, which said it's okay to segregate as long as you give equal to both sections. Colored water fountain, if you remember, white water fountain. Colored rail cars, white rail cars. As long as they were equal, that wasn't by definition segregation. That's what Plessy versus Ferguson said. So that rolls along okay until about 1954, when you have Brown versus the Board of Education. Happened in Topeka, Kansas. In Brown versus Board of Education, there was a lawsuit that said, hey, it is inherently impossible to have equal amenities for different people. Most notably, education. That went all the way up to the Supreme Court, and you get the Brown versus Board of Education, which in essence repealed the Plessy versus Ferguson law. In 1896, they said, hey, it's okay as long as they're equal to have them segregated. In 54, they said that you can't segregate. Can't do that anymore. All right? So that was the Brown versus Board of Education. Then, we roll along a few years later, you get to 1968. Now, you guys may know, you may not, but you will find a lot of times buyers and sellers won't meet each other until the day of closing. That's one of our jobs, is to insulate our clients so that they don't get emotionally controlled, so we kind of work as an intermediary. But because of that, a lot of times buyers and sellers don't know each other until closing. So there was a buyer who bought a house, put an offer in, completely qualified, had the money, had the credit, all of it. Seller sold to him. They get to the closing table and they find out that the buyer was a black gentleman. The seller, who was a white guy, said, I'm not selling to you because you're black. Bingo, more problems. This gets kicked all the way up to the Supreme Court again. And the buyer hired this really genius attorney who goes in front of the Supreme Court and in like 3 minutes wins the case, and all he really says is, Your Honor, you made this decision 92 years ago that it was illegal to discriminate based on race because of the Civil Rights Act of 1866, and here this is a race discrimination case. It's called Jones versus Maher. The Supreme Court said, you are absolutely correct. And they forced the sale of the house. But one other thing they did was, at that time, they said it's also inherently impossible to discriminate or differentiate between a person's race, their color, their religion, or their national origin. So in the Civil Rights Act of 1968, we now have 4 protected classes. They reaffirmed the race case and said, yes, you can't do that. But they added color, religion, and national origin. All right? I don't know if I'm so sure about religion anymore, because we have a lot of Asian Christians, we have white Muslims, we have things like that. But at that time, they said it's inherently impossible to distinguish between those, so they added those 3 to the race: race, color, religion, national origin. So the Civil Rights Act of 1968, the court case in 1968 becomes Jones-Maher, which ends up becoming the Fair Housing Act. That court case ends up becoming the Fair Housing Act. It transforms, it becomes Title 8 of the Civil Rights Act. That title, and they call them titles, they're at the bottom of page 33. Title 8 of the Civil Rights Act of 1968 becomes, or morphs into, what we now know as the Fair Housing Act. And at that time, we've got 4. Everything's rolling along fine. It's a joke. Until 1974, then the women get in the act. You guys remember Bobby Riggs and Billie Jean King? The tennis match, the battle of the sexes. Who was better? You guys remember who won? Billie Jean King did. So in 74, we have the Housing and Community Development Act. which brings in the next protected class of sex. So now we have race, color, religion, national origin, and sex as a protected class. Now, for a quick clarification, the term sex in this context means gender, male or female. It does not mean orientation. All right? That was not their intent in 74 to protect the sexual orientation. It was a gender issue. Man, there are some coming down the road you'll see, but at that time, sex meant gender. You could not discriminate against women differently than men. All right? So we're okay there, and then in 1988, they amend the Fair Housing Act to bring in 2 more protected classes. Whatever they were. I can't remember. Marital status and disability in 1988. They bringed in, I English well. They bringed in marital status and disability. So what you have since 88 are the 7 protected classes under the federal fair housing law: race, color, religion, national origin, sex, familial status, and disability. Familial status means family status, all right? You can't discriminate because of somebody's got kids, for instance. And we'll talk all about some of those.